Hello and welcome to yet another episode of Legal Wrangle on Indirect Taxation. In this episode, we are presenting before you cases relating to inclusion of post-manufacturing expenses in assessable value, admissibility of refund of unutilized credit upon closure of unit, and entitlement to exemption from VAT on enhanced sale prices of oil even after rolling back of previous prices. Regarding service tax, we are focusing on the issue of liability of Indian branch office as recipient of the service, SENVAT credit availability on inputs used for providing non-taxable service, and the issue of veracity of export license granted to a meat exporter. Today, we start with a larger bench decision of the Apex Court where the key issue is whether transfer of raw material between two sister concerns can be termed as sale of goods and the additional consideration are liable to be included in the assessable value for the purpose of excise duty. The present assessee is Messrs. Ispat Industries Limited. Now, let's go to Manisha for details of the case.
The assessee along with its sister concern was engaged in manufacturing of HR coil sheets and availed credit on inputs such as iron ore pellets, which were purchased from Mandovi Pellets and SR Steel Limited. As and when required by the sister concern, the pellets were transferred upon reversing an amount equal to the SENVAT credit availed on inputs that were so transferred. Further, the assessee also raises debit notes on its sister concern for recovering actual expenditure incurred by it for procuring of such iron ore pellets. The department treated this transaction between the concerns as one of sale and not transfer. Further, the amounts mentioned under debit note were also included in the assessable duty valuation as additional consideration. The tribunal reversing the decision of department held that the transfer of iron ore pellets between the said concerns was not sale of goods but was transfer of raw materials jointly procured under an agreement with the supplier. The tribunal further held that additional consideration could not be added to the assessable value for purpose of levy of excise.
The division bench concluded the matter by observing that it is reasonable to adopt the value shown in the invoice of the supplier of the raw materials on basis of which SENVAT credit was taken by the assessee where the goods are entirely transferred to a sister unit. The Apex Court held that since the present is a case of transfer and not sale of pellets, the SESTAT was correct in holding that additional consideration recovered by one concern from the other for jointly procuring raw materials could not form part of the assessable value for purpose of excise duty. Unjust enrichment by the state. Normally, unjust enrichment is by the assessee, but in the case we are reporting now, the tribunal held that the state should not be enriched at the cost of the citizen. The key issue was whether unutilized credit is admissible as refund under Rule 5 of SENVAT Credit Rules 2004 on closure of business unit. The assessee is Messrs. Srinivasa Hair Industries. Now, let's go to Manisha for details of the case.
The assessee is engaged in manufacturing and exporting a wide range of quality human hair and its products. During subject assessment year, the assessee had claimed refund of SENVAT credit remaining unutilized as the same had no possibility of utilization in future because of closure of the unit. The department, however, denied the same on the ground that Rule 5 confines its scope to permissibility of refund only in respect of exportable goods and unutilized SENVAT credit is not refundable when the input credit is availed to manufacture goods for domestic clearance.
The SESTAT observed that though there is no rule to entertain refund of unutilized SENVAT credit in respect of input used in the manufacture for domestic clearances, however, cases where assessees are unable to use unutilized SENVAT credit due to closure of their business, the refund is permissible in absence of any prohibition in terms of Rule 5 of SENVAT credit rules. In our third case, the key issue before the division bench of Apex Court was whether exemption from VAT on increased prices of petrol and diesel, which was given by introducing a proviso under Section 2 of DVAT Act would continue when the prices are rolled back to its original position? The present assessee is Indo-Burma Petroleum Corporation Limited. Now let's go to Manisha for details of the case.
The assessee was engaged in the storage, marketing and distribution of petroleum products. During the subject assessment year, the prices of diesel petrol were increased and subsequently, with a view to grant some relief in the price rise, an ordinance was passed introducing a provision under section 21ZD of DVAT Act, stating that an amount equal to increase in the prices of petrol and diesel shall not form part of the sale price for purpose of levying VAT. The prices of the diesel and petrol were, however, fully rolled back after some time. Although the assessee oil companies continued to file their VAT returns on the reduced sale price. The department, however, held that the benefit of exemption under new provision of DVAT would cease to exist upon rollback of the original prices.
The Apex Court observed that the benefit in terms of the proviso was to protect the interest of the consumers by giving exemption in respect of enhanced VAT payable on account of increase in prices of diesel and petrol. Accordingly, VAT was not to be charged in respect of such increased component as per the definition of the term sale price, which came to be controlled by introduction of the proviso under DVAT Act. However, such proviso cannot be given operation beyond the element of increase, so much so that even after complete rollback, the benefit in respect of that amount must operate. The Apex Court clarified that if the component of increase in prices ceased to be in existence, the benefit of proviso would also cease from operation. In our next case relating to service tax, the issue before the CESTAT is whether an Indian branch office can be treated as recipient of the service provided by the foreign-based computerized reservation system companies to head office situated abroad under Section 66 of the Finance Act 1994. The assessee involved here is Qatar Airlines. Let's have some more details from Manisha.
The assessee is a foreign airline company. Its branch office is in India and the head office is situated in Dubai and Doha. The dispute is with regard to the matter that the Indian branch office of Emirates Dubai and Qatar Airways Doha is required to discharge service tax liability under the category of online information and database access or retrieval service under Section 66A of the Finance Act 1994.
The CESTAT favoured the assessee and held that an identical issue was considered by the tribunal in the case of British Airways, where it was held that as the service providers and the service recipients are situated outside India and the consideration for the services rendered has also been paid outside India, the said activity would not be taxable in India under reverse charge mechanism or otherwise. In another case relating to service tax, the issue involved is whether in the case the services are exclusively used for non-taxable activity of auction sale of abandoned cargo, the assessee is not entitled for the SENVAT credit at the time of receipt of the service. The assessee involved here is Trans India Logistics Park. Let's have some more inputs regarding the case.
The assessee is engaged in providing cargo handling services and availed SENVAT credit in respect of certain services which were exclusively used for auction of abandoned goods on which no service tax was discharged. Further, they also availed SENVAT credit in respect of insurance auxiliary service which was used for export cargo. The credit was disallowed by the adjudicating authority on the ground that these services were used exclusively for trading activity which was not a taxable service.
CESTAT held partly in favour of the assessee by holding that even prior to 1st April 2011, since no service tax was payable on auction sale of abandoned cargo and export cargo, credit was not admissible on the input service used in such output activity as per the definition of input service. Therefore, SENVAT credit on the input service used for auction sale of abandoned cargo and export cargo is not admissible to the assessee. It had also held that all the subsequent show cause notices were issued after knowing the fact involved in the first show cause notice. Therefore, in the subsequent show cause notices, it cannot be said that there is suppression of fact on the part of the assessee, nor it can be said that the department had no knowledge about the fact of the case after issuance of first show cause notice. In our last case relating to customs, the issue before the Delhi High Court is whether, if the license issuing authority has not questioned the veracity of the transactions undertaken under the license, can the custom authorities refuse exemption on an allegation that there was any misrepresentation? The assessee involved here is FNS Agro Foods Limited. Let's get the detailed facts from Manisha.
Assessee's meat processing plant is located in Gurgaon, from which it was exporting frozen buffalo meat and has availed benefits of various export promotion schemes. On request of assessee, the certificate issued by the veterinary officer, customs official issued let export order, and on the basis of such order, the DGFT issued the requisite certificates to assessee to avail the benefit of DEPB and other scheme. On receipt of intelligence that assessee has been exporting frozen buffalo meat without valid veterinary health certificates and without any inspection of the export goods or post-mortem reports of the animals slaughtered, and that there was a resultant contravention of the export of raw meat, the customs officer conducted simultaneous searches on at the corporate office and the meat processing plant of the assessee and seized all the documents.
The High Court favoured the assessee and held that, as observed by the Supreme Court in Titan Medical Systems Private Limited versus Collector of Customs, if the license issuing authority has not questioned the veracity of the transactions undertaken under the license, the custom authorities cannot refuse exemption on an allegation that there was any misrepresentation. It was also held that if there was any misrepresentation, it was the licensing authority which had to take steps to cancel the license. It was observed that no portion of the impugned SCNs was different from the earlier show cause notice and the consequent adjudication order passed by the Deputy DGFT. It was thus held that the impugned SCNs issued to the assessees more than 1.5 years after the Deputy DGFT exonerated them of the very same allegations is nothing but a harassment of the petitioners and an abuse of the process of law. Well, this brings us to the end of this episode of Legal Wrangle on Indirect Taxation. You may write to us your comments, criticism and counsel at editor@tioltube.com. Please do subscribe to the TIOL Tube channel on YouTube. It's free and will keep you updated on our new posts. Have a good day.